Keith mentioned the Harper resolution that was adopted some years ago. It's interesting to note that even in the English version of the resolution, it said "Les Québécois form a nation," and of course it was Harper's astuce to add "in a united Canada." The word Québécois was in the French version, even in the English version of the resolution. And when Harper was asked, well, who are the Québécois? Harper responded by saying, they know who they are. So a big problem with the amendment that Keith has referred to and very, critically taken apart is the ambiguity in the words that are used. The ambiguity in the words Québécois, nation, and it is clear to me, at any rate, that it is the attempt to do it unilaterally will simply not succeed. The first question that Marlene Jennings was asked at the hearings at the National Assembly was, by Minister Jolin Barrette, was, do you agree that French is in decline? Well, it is true that there is a decline in the percentage of mother tongue francophones, and that this will continue to decline. However, it's equally true that all other indicators are either neutral or positive in favor of the use of French. That includes language spoken at home. The absolute numbers of francophones continues to increase. Linguistic transfers are increasing in favor of French. 1 in 3 Anglophones, for example, has a francophone spouse. It used to be 1 in 5, then it was 1 in 4, and now it's 1 in 3. And the children of those unions speak French more than English. So to say that the French language is in decline, while mother tongue francophones might be in decline in terms of a percentage, every other indicator is either neutral or positive in favor of French. So this is the big lie. It is a big lie that has been repeated constantly, loudly, so that it is seemingly accepted by a good part of the population. Now, nationalists allege a consensus. They allege it in favor of Bill 101, and they allege it in favor of Bill 96. But it's a false consensus, because everyone can agree that language legislation is necessary in Quebec, and there's a consensus on that. But there's no consensus on the specific provisions. When Quebecers are polled, would they like to be able to choose the language of instruction of their children? It's massively in favor of freedom of choice. In fact, I recall when I was president of Alliance Quebec, Jean-Pierre Charbonneau of the Parti Québécois was floating this idea of having legislation that would allow a referendum to be held if 250 signatures could be put on a petition. So I piped up and said, well, great, because we'll easily get 250 signatures for a referendum on freedom of choice in education. And then within days, the PQ withdrew the bill. So there's no consensus on the specific provisions. Language of signs, for example, the very rare polls that are done, of Quebecers, would you find it acceptable if French was required on outside signs, but other languages were allowed of equal size? Again, it's massively in favor of that solution, and yet there's a constant nationalist refrain that there's a consensus in favor of the existing legislation. A word on the notwithstanding clause. Colin got into it at some length, and I won't repeat what he said, but the provisions on the language of the courts will be challenged based on 133 of the BNA Act, the 1867 Constitution Act, which provides that English can be used in Quebec courts as a matter of right. And Keith mentioned the 2 Blakey decisions, which made it clear that Section 133 provides for the use of English in the courts and the National Assembly. Now, the provisions on the language of signs in Bill 96 will be challenged not based on the Charter, but based on the exclusive jurisdiction over trademarks. Under the Charest Liberals, the OQLF changed its interpretation of the Charter of the French language to require French descriptors on English trademarks. And this interpretation was challenged by large retailers like Best Buy and Costco, and they won in the Superior Court and in the Court of Appeal. So Bill 96 simply takes this interpretation, which has been invalidated by the courts, and reintroduces it through legislation. It's almost certain that this attempt will also be struck down. It seems to me that much of Bill 96 is a provocation. It's a provocation, and so that when parts of it are struck down, as they inevitably will be, it will allow Legault and his cohorts to turn around and say, you see, they are preventing us from protecting our language. And we'll have to have a referendum on independence to solve the problem. Now, the notwithstanding clause does not protect the attempt to insert the affirmation that Quebecers form a nation. As Keith pointed out, it is invalid for all kinds of reasons, not the least of which it's an attempt to do it unilaterally. Now, the provisions in Bill 96 that are not protected by a notwithstanding clause, or that are protected by notwithstanding clause, could be the subject of an immediate complaint to the United Nations Committee on Human Rights. Under the International Covenant on Civil and Political Rights, freedom of expression is a guaranteed right, and there's an optional protocol attached to the International Covenant, which allows citizens within states to complain about the conduct of their state. And it's happened, many of you, I'm sure, recall, in the Ballantyne-McIntyre case, when the Supreme Court struck down the exclusive use of French in the Ford case. Bourassa convened the National Assembly and invoked the notwithstanding clause. And then 5 years later, in April of 1993, the UN committee came down and declared that the exclusive use of French was a violation of Canada's international treaty obligations. Canada's international treaty obligations. And within 2 months, the National Assembly adopted Bill 86, which has the idea of marked predominance. So there are right now 2 UN complaints in the works. We have exhausted our domestic remedies with respect to the language of signs provisions in Bill 101. We have exhausted our domestic remedies in the Gosselin case, which went to the Supreme Court when it comes to the language of education. So there are already 2 UN complaints being drafted and will be filed hopefully before the end of the year. But with respect to the rest of Bill 96, where many of the provisions are protected by notwithstanding clause, as soon as it is adopted, domestic remedies having been exhausted, complaints could be made to the UN Committee on Human Rights, and it's something that should be seriously contemplated. One of the things that is, I think, a particular vulnerability of ethnocentric nationalists, and Andrew touched on this in his talk, Quebec has the highest rate of immigrant outmigration in the country, any other province. And this includes Francophone immigrants. And this was confirmed by a study done by the Fraser Institute and the situation about 5 years ago, and the situation continues. We should ask ourselves, why are immigrants leaving? And I put it to you that the short answer is that they came to Quebec to become citizens of a G7 country. They did not come here to join a tribe. And when they discover the ethnocentric discourse so prevalent in Quebec, they leave. Now, the original draft of Bill 101 provided that French was the only official language of Quebec. The word only was removed on the grounds that it risked being struck down by the courts. Those were basically the comments I had to make because everything has been so well covered by the speakers before me. I just want to make an observation. The way Bill 96 can be viewed as an attempt to take Canada out of Quebec. Ethnocentric nationalists have tried to take Quebec out of Canada. They have not succeeded. So Bill 96 is an attempt to take Canada out of Quebec. And if we do not firmly oppose this bill in every way, and in every forum possible, this bill may very well succeed to the detriment of all Quebecers. Now, one of the things that will be available to contestants of Bill 96 is the Court Challenges Program. Now, Prime Minister Trudeau has referred to the Court Challenges Program as being a means to allow for the protection of minority groups. And Mr. Blanchette of the Bloc Québécois has criticized the availability of these funds to people that plan to contest Quebec legislation. In fact, the MSB, in its challenge to Quebec legislation, was publicly embarrassed to returning the money that it received from the Court Challenges Program. That, in my view, was a mistake. There's work being done now. These provisions of Bill 96 that are so obnoxious will be challenged. Funding from the Court Challenges Program will be sought, and we're not going to give it back. So thank you for your consideration.